This broadcast is about the bills of exchange, and we have been working on reading and uh, strategically examining the bills of exchange to get a clear picture of uh, its and an understanding of what its purpose is. Okay, we've already gone through the first, I would say, the first half of this. If it were a page, would be the first half of this page. We've gone over acceptance. We have did a lot of examples of what acceptance is, but I'm hesitating to scroll past that, even though we have already gone over it, because there are so many aspects to acceptance. And when people couple that with the words conditions of acceptance, um, some people are referring to their presentments as condition of acceptance uh, affidavits or what have you. And I don't think that's the correct terminology to use to get a good understanding of what it is that you're creating. Because a condition is not a type of document. It is um, exactly that. It's the condition of the kind that are governing the document. Okay? Whether it be negotiable or non negotiable. We discussed that. We haven't gotten down to the ends, so we'll encounter that and we'll probably have to rehash all of that so it can all be tied in together as far as the understanding of it all in totality in relation to each other. Okay, next we discussed acceptance and how it's completed, delivery and how that's performed, notification and what qualifies as notification. One thing I learned from Yusef teachings is that any of these procedures that you must remain in honor, and that's what gives you um, leverage in any case when your opponent um, has acted in dishonor. Okay, that is the reason you can file for different types of motions, and you can um, even file summary judgment um, motion for summary judgment when you have clear-cut evidence that your opponent is acting in dishonor. When you have provided proper notices to give them an opportunity to correct their actions, okay? And Yusef speaks a lot about this in his teachings, but he doesn't focus on its importance as much as I think he should, even though he mentions it a lot. What I mean by that's one of the pertinent aspects of all of these processes. And he is aware of its importance. And you know that based upon the fact that he always mentions that you always are supposed to give notice, or he'll clarify what his understanding of specific documents are, he'll let you know this is not a filing, this is a notice. This is a notice, okay, type of filing. And so I'll give you an example of that. Some things are not the actual instrument, it's a notice, it's an offer of acceptance. It's an offer. It's not a condition, it's an offer. Whatever you put in that offer is a condition. Upon which that person, what you're offering for them to accept. Okay? I'll give you a good example. If you have an affidavit of estoppel, which is creating a contract or an offer to create a contract, and a lot of people assuming that it automatically creates the contract. Well, the affidavit of estoppel is a contract, and it is effective upon delivery. In other words, when the person gets the contract or receive it, it is effective upon them receiving it. They can't agree to something if they haven't even received the terms. Now, in the case where you're writing, see a person who is pretending to be a creditor, okay, and you're letting them know that you're putting a stop to that. Okay, that's what an affidavit of estoppel is. You're putting a stop to that. And you're setting another course. And you're redressing the contract. It's a renegotiation of sorts. Okay? So once you type your renegotiation document and send it, and and you send it certified mail, when they receive it, or even if they haven't, well, let's say if they haven't received it, because when you have a certified mail, they're gonna track that particular instrument because it has value. And so they're going to make sure that the person get it. And so what I'm saying is, even if they don't get it, even if they claim they didn't get it, it will not be effective as a defense. Because the certification tracking that certified that it was delivered to that address, that's a wrap right there. Okay? Now the clock is ticking on the time that the court will allow for them to, for you to say, okay, I gave them enough time. I gave them 7 days. Depending on what the situation is, I gave them 3 days from the time they received the notice. I put on the notice that they were supposed to follow these instructions on demand. Okay? And so the reason you will put on demand is because you don't want to let them think that they have time to jack around. And you also need to write on there that they're going to need to be responding to your offer to let you know that they would like to counter offer. You have to allow them to counter offer or rebut it. If they don't counter offer with a rebuttal, that's what a lot of people always say, well, they didn't rebut it. They don't have to rebut it. They can counter it. They can ignore it and wait and see if you're going to do something about it. That's what action is. They don't have to take action, just like sometimes when people send you letters and you ignore them. And then it's up to them if they want to do something about it. In some states, creditors are quick, like California, creditors are quick to take you to court behind a credit card, right? Uh-oh, boo, get out of my broadcast. Y'all doing the most. Get out of my broadcast. Okay. And the reason that they are quick to take people to court is because the judicial system there allows them to garnish wages and so forth and do aggressive action to uh, get their judgments set to settle their judgments. Okay. And then in other states like Texas, they don't allow that. Okay. For a credit card company to do that, it's illegal anyway. So Texas doesn't allow that. It's illegal because many times they double book it. They didn't already received, they securitized the loan, the security agreement, and then made you think that you owed them money and they are the ones that owe you money. And so they be wrong anyway. And also, some people know how to get tax credits to cover that obligation and set it off, discharge the debt. So there's different ways that you can handle this matter, and choosing to litigate against somebody that's helping you is of course egregious, to say the least. It's egregious, and that's what gives you the right to take action. Action includes counterclaim. Counterclaim when they try to sue you. You can counterclaim. All right, let's move along. We spoke a lot about counterclaims and set-offs. Some people refer to set-offs as discharges. It's the same thing. It's the same exact thing. There's no big difference in discharge or set off. I'm going to tell you another thing. It's not a big difference in the words discharge, set off, debit, and deductions. Debits, credits, and deductions. It's all the same. Discounts. What else is another name? Y'all type in the comment section. What's another name or an equivalent value that would, as far as words are concerned, that is equivalent to the words discharge. Set off. Set that shit off. Discharge it. What is a set off of a claim? A set off of a claim is when you say, and somebody say you did them some harm, and then you say, well, you did me some harm. Set that shit off. We equal, you know. Nobody owed nobody nothing. Because what you did to me caused me harm, and what I did to you caused you pretty much an equivalent value of harm, so of damages. So set that shit off, okay? Balance it out. That's what it means. Balance the books. No harm, no foul, because there isn't anything to calculate if it cancels itself out. There isn't anything there won't be any overages. In other words, okay, a set off can be used to set off a counterclaim can be used to set off a portion of the claim. Okay, you can say you owe, the person may say you owe me $100,000. Okay, and then you may say, well, you did this to me and this and that, and according to the rules, that's at least $10,000 worth of violations that you owe me for violating my consumer credit rights. Okay, you make a consumer credit claim against them as a counter claim. Well, what happens in that predicament is the claim, if the claim is validated, well, that's exactly how you would present it. They did this to me, and so even if I'm found guilty for the claims that they have against me, some of the claims, $10,000 worth of claims that I presented with evidence, can be set off to lower the claim amount of restitution. Okay, set that shit off, or discharge it, however you want to put it. It has to be deducted. Okay, that's another word you hear in taxation and so forth, deductions, because it has to be deducted from the amount you claim that I owe you. If you claim I owe you $100,000 and I claim you owe me $10,000, then you have a claim for $90,000. If that's what the judgment would be for, it would be for $90,000, and that would be clear on the onset. That, you know, from the jump, that okay, even if you win, my counterclaim presents value that can be used in this transaction to set the shit off. Okay, I have some interest in this counterclaim that can be used to set this off. The liability that I've incurred in your claim, I would like to use my claim against you to set it off. Okay, I'm seeing it in different ways because you gotta understand the concept, and seeing it forward and backwards and backwards and forwards helps with that. Business of banking is dual accounting. Forwards and backwards, backwards and forwards. Banker is the borrower. The borrower is you. When you borrow, that includes the banker is the borrower when you borrow. See that? Forwards and backwards, backwards and forwards. The banker is the borrower. Let's take that back a second. And hang right here just a second. Okay? And get the gist of this part right here. The set off and claim. The banker is the borrower. Okay? When you borrow, it's the business of banking. The banker is the borrower. When you borrow, that includes anybody or person's business, whether incorporated, public business, or not. It's considered private banking. Whoever carry on the business of borrowing is banker. Now that's a hard pill to swallow right there, and that's not for everybody to understand that. Okay, so I'm gonna reserve the in-depth understanding on that for people who are in the business, who carry on the business of borrowing. If you carry on the business of borrowing, you're a banker. They say you're a private banking. It's considered private banking when you carry on the business of borrowing. Going to all these loan places and you borrowing. They calling you a borrower. Okay? So which one are you acting like? Are you acting like the banker, or are you acting like a borrower? You're not acting like a banker? So why are you borrowing? Moving right along. If you want to act like a banker, then there are banking rules for anyone who want to carry on the business of banking. This is why a lot of people, estates has been filed bankrupt, because they already considered you as a bank that was insolvent. I mean, you couldn't handle your business right out of simple resentment. So why you thought you could file 9(8) trusts and all of that when you couldn't even perfect a simple instrument? You whining about somebody sent you back a nasty letter. If you knew what you was doing, you'd know how to send them back a nice nasty letter. Notice I said send them back a nice nasty letter. Stay in honor. Remain in honor. Then you still say, remain in honor. Okay? A gentleman remains in honor. I don't care if you're a female doing business, and the Bible say in business be men. My Bibles and bills. The Bible say in business be men. I mean, handle business the way business is supposed to be handled. That's what my papa taught me. See, I was bred in business. Okay? I have an inheritance of wealth. All the promises in the book ain't yours. I ain't gonna keep telling y'all that. Yes, I am. Because you got to understand what that means. That's the only reason. You got to get an understanding of what stuff means. Not just thank y'all for the likes. I guess y'all dipped in and liked it and left out. You wasn't interested in learning no anymore. For right now, perhaps you'll view the video later in your spare time when things get crucial. A lot of times people will pay for these processes because they done waited until things got crucial and now they want to hurry up and get remedy right away. And that's the reason why on Master will tell you, you self-will too. Don't come running to me when you in the middle of an eviction and or finna be evicted, and then now you want to come ask for somebody to do your paperwork and your documents for you when you was bullshitting around when you could have learned it all the while. Instead of filing them papers, you should have learned this document first. That's one thing I commend Mansa on. He do stress, if you learn the bills of exchange, you will not need him to hold your hand. Because the bill of exchange is not self-explanatory, but just if you study this, you will learn all different types of laws and things that affect, would have something to do with you, one way or another. See how all this stuff tie into each other? It ties into each other because people are saying, oh, you're mixing process. It's not mixing process. Some of the processes are the same. They are already mixed. They're the same. We just call them by different names, but they're the same. That's like people call God by different names, but it's still the same. Spiritual entity of higher intellect that we're referring to. Okay? Whether you call him the creator or the author. Some people say he's the author and the finisher of our faith. Yeah, they call him all those names. But it's still in reference to the same understanding of who you're making reference to. Okay? So we all know we're talking about the same person or the same entity of higher intellect. And in many ways, we agree that there is a God, even the atheists. Okay? Because they believe in politics. They believe in science. That's their God. So they believe it's somebody you got to follow with higher intellect. See, that's no different. It's different, but it's not different. So as you learning these words to understand that some things is different, but it's not different, then you can piece all the puzzles together. Like some people have gotten an understanding that many of these processes are ran through bankruptcy court. Even the criminal cases, they running that shit through bankruptcy court. You don't see it. They fingerprinting you and stamping and documenting and stamping and sending and delivering and sending. You create credit cards. They got Q scanners and all this shit now in the jails. It ain't nothing but a human trade system. Trading humans like cows. Branded cows. These cows belong to the United States. And that's why some people feel the need to correct that, and they call it correcting their status. But none of the documents that you find within the systems even allude to the fact that there's a status to be corrected. What kind of status are you correcting? See, in order for a status to be corrected, it would have to be incorrect. If they listed you or me as insolvent and not knowing how to operate as a banker, to handle my estate, that was not incorrect. That was not incorrect. And so I'm not correcting that they have that there. What I am correcting is the fact that when you took over my estate, you had a fiduciary duty to do a better job than me and make sure that I was taken care of. At least when I was handling, I was well taken care of. Now you handle it, you well taken care of. That's a misappropriation of my funds, to my estate. So if it's not to my benefit, that means somebody has completely taken over and have usurped authority that they don't have a right to do. And you prove that they don't have a right to do it by making sure that you raise your competence. If they are incompetent, then you need to raise your competence level. Raising your competence level is not and cannot be achieved by running to your favorite guru. You're only proving that the status they gave you is correct, or that they assigned you to. It is correct indeed. So That's why filing some of your people that's filing the same documents. Some people's are being accepted and some people are not. And it's because after they get so many and all y'all paperwork is exactly the same, they come to the understanding that, oh no, we ain't gonna go backwards on allowing the other ones to go through. We can't go backwards. But we can put a stop to this minority train, because there's an aspect in there that people are not understanding that I will not disclose, because people are really gravitating to the information that I'm providing and they're not giving me credit to. All right, I need credit for this information that we're disseminating. Remember, you heard it here first. Share, tell others. Bankrupt. We got to this area about bankruptcy on the previous episodes, but you will find that on the episodes on the bills of exchange that we may go back up and recap and do a little more expoundatory explanation so that we can touch on all the angles and all the aspects and all the dimensions of understanding that could be derived. They call it implications. In innovation, they call it implications. The implications of this instrument is amazing. It's godlike. Just got to understand it. Work with it instead of against it. Get in alignment. That's what this live reading is about. I'm going through this with y'all. Y'all going through this with me. Okay? And we can get in alignment with the rules and understand what the rules are. And stop pouting about who's using the rules. And we don't see the benefit in the rules because you're not operating in the rules. That's just like if you're playing chess and you don't move your men like you need to, you'll start seeing your opponent just start snatching all your men off the board. You're like, man, I don't like this game. But you're not understanding that the only reason you're losing is because you have to learn the rules. Once you learn the rules, you'll stop making moves that put you in a losing predicament. Okay? Now, I was doing a lot of things that I knew should have prospered. That's what alerted me. Okay? I knew. I was like, oh no. That's just like when I was building my channels and people was taking all my ideas. They still do it. And I was setting trends back and forth and back. Then I set a trend about setting trends. Then I set a trend, I just kept setting trends. And I also kept learning. So I started doing some research to find out what can I do about this. These people are not paying me. Facebook owe me. YouTube owe me. What can I do about this? And as I began to search what my legal perimeters and what legal uh, laws and codes and so forth that govern these type of agencies is how I came across this platform. So I already had a lot of things that people are trying to get. I'm on the back end of it trying to say, wait a minute, I must have done something wrong because I know God gave me the ideas that He gave me, and I know God told me that they will prosper. And so if I don't see things prospering, I know something is wrong. Something has gone awry, terribly awry. And a lot of these creditors, seeing that I had so much and I ain't know what to do with it, are not, they aren't creditors, they financial institutions, and they are stock exchanges. They are not creditors. That's why they steal people like me. They steal our identity. And when I say people like me, it's people that are producing a lot. I produce a lot. I pump out creative new instruments every day, all day. I'm a bad bitch, you understand? I ain't bankrupt by no means. Okay? I just don't like to brag about my money and all that. Okay, and what I got. Because even when they put I'm gonna tell you how cold I am. Nah, I'm gonna let y'all, yeah. But even when they put a block on my bank account, I got another kind of banking system. So all I did is just went to my private banking system and lived off of that till I figure out what is going on with this public system. Okay? But I ain't never broke. Please believe I ain't never broke. A lot of people who are relying on these electronic systems, they can easily be broke. They don't have no value. I can't never be broke. Everywhere I go, I start over and I build myself up from nothing. Just to show I can do that because I extract value from myself. I extract value from myself. I don't go trying to steal it from nobody else. I educo. That's what the word education or educate is derived from the word. If you read the book Think and Grow Rich, I hate reading books, but certain books like Think and Grow Rich are very vital to opening up my eyes to seeing certain things. I saw it like a Bible. I see these bills of exchange like a Bible because I'm very familiar with the Bible. I'm very familiar with the Bible. You can't tell me something is in the Bible that ain't in there. I can know that it's not in there if it don't sound right. If it have a different interpretation from the truth, I know it's not in there. You can't tell me it's in there. And every time I challenge people when they think they gonna make up a scripture just because I said I haven't read the whole Bible in its entirety, that doesn't mean that I don't know what's in there. I know what's in there, and I read enough of it to know what's in there and what's not in there. Because it don't fit the bill. It don't add up. It don't sound right. And they don't ever be able to find this so-called scripture they claim is in the Bible. They'll never be able to find it because it ain't in there like I said. See, I can stand on those grounds. Not because I believe in the scripture or believe in the Bible like a religious sort of understanding, but because I have read it in depth that much. I studied the Greek and the Hebrew, the Chaldean language that it's originally translated from. That's how in depth, and I would do just like I'm doing this bills of attendance. I take my time with it, baby, and finesse it. I got a song that say, slow down, you're moving way too fast. Slow down, I want this thing to last. Relax, take that off, you can leave that on. Curtains up, we can dine in, we can make this a night to remember if you just slow down. Some things you gotta handle with fitness. Slow down, yeah, slow down. You're moving way too fast. Some things you got to handle with finesse. You can't rush it, baby. If you really wanna experience, you got to slow down. If you really want to get an understanding, you got to slow down. Some things you got to handle with finesse. You got to slow down. That's why I wrote that song. I notice people always in a rush to do nothing, to get nowhere. Slow your ass down. That's why they have the right to list you as bankrupt. But slow your ass down, help you pay attention to what's really going on in the picture. They had to interrupt our services, okay, for us to see that they didn't have a right to do that, right? Made you angry. Like, wait a minute, something going on here ain't supposed to be going on here. I mean, I remember watching Kid W. Estates, and she said she felt something was wrong. You feel it. And I feel you. 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 Walk with me, talk with me, and tell me what's on your mind. Yay. I wanna feel you. I hear what you're saying to me. I hear the words you speak, but I wanna feel you. See, the more you get to know and understand who the person is, this is why you'll see a lot of people making emphasis on the person. I want to feel you. Bankrupt includes any person who estate is vested. Uh-oh. We back to that word vested. Have y'all found out what that word vested means? It's vested in a trustee. That means you holding that trustee responsible. Like I said, I was holding them. I would expect that when I was doing very well in a lot of my businesses, I would expect that the trustees who are in charge of my interests would have contacted me and in clear and concise language relate to me, ma'am, you have nasty, ridiculous money that we need to do to draft up some papers so we know what to do with all this money you got, ma'am. That's what they were supposed to have done. Because I already know I got the money. I know I didn't know that I, in my personal account, transacting too much business through my personal account. I didn't know that. And so, in that regard, I was knowledgeable of a lot of things in business, but it was like simple things that mattered a lot. And I was missing those, some little gaps in there. But that's what the trustee is supposed to do. He's supposed to be able to trust the trustee. Like if you don't know nothing about doctoring and you expecting for your doctor and you trusting for them to not recommend you no medication that'll kill you, that got side effects that'll kill you. That's what vested trust is. You vested your trust in this motherfucker. He gonna recommend you to take some medication that'll kill you? Come on now, that don't add up now. Something in the milk ain't clean. That's what I discovered. Something in the milk ain't clean. These trustees is out of order. So I had to call things to order. And I understand that now. But the only way to call things to order is you got to correct yourself. That's how you correct your status. Correct yourself, your understanding of what's going on. Then you can do something about it. You got to know what's going on first. And then people is inciting you with all these angry speeches. You ain't gonna never get the truth. They just relaying to you they angry speeches. It's all minor talk. Everybody mad at somebody. They mad at everybody but theyself. I could kick myself in the butt when I realized that I was responsible to perform in ways that I had not performed because I didn't even know about that kind of stuff. I just didn't know. And that's the only reason I didn't perform, is because I didn't know. Baby, if I'd have known about this bills of exchange, oh man, y'all don't even know. Just since I found out about it, I just been doing the most. I've been doing it. Just knowing pieces of it. Man, hold up. If I had known about this years ago, oh my. But we learn things in the right timing. But if I had learned about this years ago, oh my God. When I started the record label, oh my God. I would have already known when my stocks was supposed to mature, and been on that and made sure that I did make sure I did title deed transfer, interest, all that transfer, setup, transfer, all that. I am just shouting out terms because they don't. That's stuff that's not applicable to everybody, and sometimes I don't want to share too much because people not ready for that. Like people trying to be trustees and don't even understand the high level of responsibility of a trustee. I do know that Miss Jackson, she trained people to be trustees. She a bad girl. Her name spelled M-Z Jackson. Miss Jackson. Bad girl. Bad girl. She cold with it. So if you ready for that level, you can go over there and glean from her. But these systems not for everybody. Don't start there. Don't start there. Because even some of the things she's saying, she be wrecking, okay? But she doing it with based on legal grounds, not haphazard accusations. She can calculably explain out everything she's saying, okay? She can calculate the understanding and relay it to you easy because she calculated it. She didn't just grab it out the sky. She calculated it to that understanding. She can tell a judge how to calculate that shit. Okay, this is what happened. This occurred. When I sent this, I affected the postal rule. This is contract law based on this code. She know the codes by heart. She rattle them motherfuckers off like a G.O. go. You dig? She cold with it. And now, I don't know. I've never really watched much of her content. It doesn't get into the court practices because she handling that administrative so-called, she don't even make it to court. That's what I'm talking about. She handling that administrative so-called, it don't even make it to court. And that's skills. If they're testing your evidence, then that means you haven't presented enough evidence to make them go on fold. Show the hand. You haven't showed your hand enough for them to fold. Okay? And a lot of people be holding on to what they got for evidence. But if you are the plaintiff, then some evidence is good for you to let your opponent know, hey, this is what I got in my ammunition, and that I'm not withholding. And I don't want to claim attorney-client privilege on these particular documents because I need you to know I got ammunition. And I may be disclosing this particular document to you because I ain't got no problem letting you know we finna start right there. But where we finna go with it, you figure out by what you submitted. That's where we gonna start. We gonna start with what you submitted to the record. That's where the case gonna begin, and that's where it's gonna end. By what you submitted in the court. If what they submitted in the court is inadmissible or evidence against them, then what else do you need? They submitted the evidence in the court for you. They complaint or their response to your complaint is sufficient. The grounds start right there. Start right. Start from right there. That's your case. Rip apart every fucking word they said, every statement they made, and this is how you do it. You want to do that with their complaint or with their response to a complaint because of the fact that that is on the record already. You don't have to worry about it being submitted. They the ones submitted it. You don't have to worry about them objecting to it. It's inadmissibility. Okay? Because they are the ones that submitted it. And once they submit it, you can use whatever, you can do whatever you like. This is why a lot of lawyers hate giving information. They know it can be used against them. They know it. They always holding, because they know it can be used against them. They understand at least that aspect of it. But if the other opposing lawyer that's if they're not withholding information in their what do you call that, transparent, then they have a right to tell the other opposing attorney, counsel, look, you need to be transparent. We're transparent. We've provided you. We are not claiming attorney privilege on all our documents. We've let you know where our case is going to be sourced from. It's going to be sourced from the complaint. Now, what do you have? Are you sure you submitted everything and anything that you're claiming privilege on? You've submitted a log to the court to be examined ex parte to see if it qualifies. Have you done that? And that forces them to comply. It forces them to do the right thing. If they don't, then you have grounds to win anyway. You have grounds based on that. You have grounds to have them sanctioned. So they can play silly games, but it's rules to this. Rules of code of conduct. Remain in honor. Assignee under the law for the time being is in force relating to bankruptcy. So that's a temporary power of attorney. We discussed that yesterday. Okay? The bearer means the person in possession of a bill or note which is payable to bearer. We also discussed that. Who is the bearer? You is the bearer. I am the bearer. Whoever holding the note is the bearer. Whoever created the instrument is the bearer. The person they sent it to is the bearer. The person who is the carrier is the bearer at some point. It's a temporary bearer. That's why it was discussing for the time being in force. Okay? The carrier is for the time being an enforcer of the note. Okay? He's like the bailiff, the postman. Talking about bills. Bill means bill of exchange. Okay? Also means note. It says and note means promissory note. And so when this particular document is using these words, they want you to know that they're not referring to any other understanding other than this is exactly what they mean. It is a promissory note. They just shortened it and said note, called it a note. And I'll go even further to give you an in-depth understanding. A note is a notice as well. A notice is a note. It's a promissory note. I'll give you a good example. When your bill, your utility company send you a bill, an invoice, whatever you want to call it, for services. And on that invoice it say, if you don't pay this by such and such a date, I'm going to cut your shit off. That's a promise. That's a promissory note. They're recontracting with you. Say, we're going to cut your shit off if you don't pay this money. Okay? They trying to recontract with you. They trying to get you to think that the words mean something else. Okay? But the reason that the promissory note is not enforceable, okay, is because remember I said about the dual accounting? All right? So everything, if you transpose it, you'll understand what it's actually saying. All right? So just as I said, it's saying if you don't pay this money, we promise we gonna cut your shit off. That is a promissory note to you. When you fill out your mortgages, and it is a clause in there, and they make sure you they go over this clause with you. That's section 22 of your mortgage. That's the area where it gives them, you're giving them permission and power of attorney to place a lien on your property and make claims that they have ownership of the note, and you have a deal to pay them money. And if you don't pay them, they promise to foreclose on your house. It's a very vital section that's required in all mortgages. Okay? All mortgage loan applications is required to have that section in there that say that they can foreclose on you, and also it says that you have they have to send you a letter and offer for redemption, a redemption notice. Okay, send you a letter of redemption before they proceed, and when they once they sent you that notice allowing you to redeem yourself, to show them that you know how to send a presentment. That's what it means. Okay, let's move right along. Delivery. We discussed what delivery means. Transfer of possession. When you transfer the possession into the hands, your contract um, with, say, for example, they sent you uh, your bill and you never did look at the bill, you just paid it. Okay? And so every time you keep paying, they have evidence against you that you've been paying on this bill. They have the delivery of the payment to prove it. It's evidence against you. This is why in the courts, the first thing they ask, do you have a payment history? The payment history is evidence against you, okay? In a way, unless you can explain how they acquired that payment under, uh, misleading pretenses and um, that you owed them money and that they weren't honest with you to disclose um, what was being transacted at your closing. And you need to be able to articulate that so that the court can receive your other evidence when you submit a document showing that you sent them a letter stating that you wanted to cancel all any other contracts that you were not aware of what the terms was. But um, I would even suggest send a letter of intent first. Hey, Bank of America, um, it's come to my attention that I have some interest unaccounted for. And so, in that regard, I'm wanting to um, revoke this contract and, settle my interest in this um, agreement. And the reason why you want to tell them you want to settle your interest in the agreement is because they understand what that means. They know what they done. You don't have to accuse them of nothing. If they send you a letter back saying that they don't understand what that means, now you have evidence that they playing silly games and that you tried to address the fact that you had made some payments that were unaccounted for. So if they try to submit the payment schedule in the court, that's going to only show those are the payments that's unaccounted for. That's evidence for your side. You get a copy. You go to the portal, the court portal, and you get a copy of their evidence. Use all of their evidence. You don't need your own evidence a lot of times if you learn the art of using what they provided. Because they're going to always be wrong. They always wrong some kind of way because they're doing crooked stuff. So it's easy for you to use what they're filing as evidence because it's something wrong on there on as far as the proper procedure that it was supposed to have been filed of the way that particular document was supposed to have been filed. First of all, it was not supposed to have been filed without your agreement, consent, or knowledge because you had no clue that a bond was created and that money in changing hands, money changers. That's what the Bible talk about, Jesus beating the money changers because they was doing shit like this. They was out of control. The whole reason. They was out of control. It's not about having money, it's a problem. It's when you're doing somebody wrong to get it. Delivery means transfer of possession, actual or constructive. We discussed that yesterday or on the previous broadcast. Constructive delivery is when there's a go-between. For example, um, what's a good example of constructive delivery? Uh, constructive possession. A possession, actual or constructive. We used the example about a drug transaction or deal on yesterday, but I wanted to use something more professional for the people that are not familiar with that type of lifestyle, so that we be versatile and give examples that are relatable to all um, types of people from different um, cultures. You got to be able to have relatable understanding so that you can understand. And so constructive mean I'm the go between. All right. I have possession of it. Okay. When you go to the counter and you've already selected your items, right? Before you get to that counter, I done seen people, especially during the Christmas holidays and Black Friday. Y'all done seen these, probably on reels or shorts of people acting a fool in a store. And they haven't even purchased the item yet. They acting a fool because in their mind, if I got to it first, I picked it up, I put it in my basket, it's mine. And so that's constructive possession. They haven't purchased it yet. But in all due respect, it's in my motherfucking basket. Don't take my shit out of my basket. Talking about you thought that was an overflow basket sitting to the side. No. You shop from on the shelf. And there's people, some fights done broke out about constructive delivery. No, they have not delivered the money in exchange for the possession of it. But in their mind, they have the money. They know they have the money. They know they want the item. It's theirs. They picked it up. They put it in their basket to distinguish that they want it and show and act in a manner that they to show the general public that they have selected these items. They put them in their cart and drove off with that motherfucker. Okay? Right? Even if you collecting stuff under your arm, use the vehicle, you drive off with it in your hand. You mosey on. People call it moseying. It's the same as movement. You moseying along, picking up your few little items, little bachelors and stuff. You may get a few little items here, a few items there. Might not need a cart. But the same concept is applicable. Once you tuck that under your arm, it's yours. You don't expect that if you drop it on the ground that another customer will pick it up and claim it when you the one took it off the shelf, okay? Or make claims that, okay, I'm finna go buy this. How you finna go buy that when I was finna buy it? I had constructive possession. And as with the banks, they have constructive possession. They constructed a belief in your mind that you owed it them, and you have been acting like you owed them by making payments. That's constructive delivery. You performed on the act from one person to another. You performed on the act. Okay? Now let's find out about that holder. I like that holder. I seen a court case when I was learning about these different things, and I would go and look things up. When I see a word here, I'll go look up a video specifically about the word and get some in-depth understanding. When I found out about this holder is a motherfucker. Huh? That holder means the payee. Mm. Yeah, I want to be a holder. You want to be a holder? Yeah, I like holding. A holder means the payee or endorsee of a bill or note who is in possession of it. A holder means the payee or endorsee of a bill. So the holder is the payee and the endorsee, and or the endorsee. Or you got to be one or the other. You got to either, oh, because you can no longer be the holder if you endorsed it. Because you got to deliver it after you endorse it. Got it? All right, I just learned something else. The holder means the payee or endorsee. Because when you have it in your hand, you the holder. Okay, I'm just saying figuratively. If you have it if you possess it, it's in your possession. You the holder. When you release it out of your possession to make an exchange, you shapeshift into being the endorsee of a bill or note. Okay? The holder is means the payee or endorsee of a bill or note who is in possession of it. Okay? Once you're in possession of it, you the holder. You the bearer. See that? Or the bearer there. We discussed that bearer. Them just a different name, a holder and a bearer. All right, a holder, bearer, and an endorser right now. All right, endorsement means an endorsement. Wow. Completed by delivery. Okay, so once you deliver the endorsement, it changed from a INDORSEMENT to a ENDORSEMENT. Wow, you see that? Endorsement means an endorsement completed by delivery. So it changed from an ENDORSEMENT to a INDORSEMENT. Hmm. Let's scroll back up. So, if the signature changes from endorsee, that occurs during delivery when possession changes hands. When the bearer is holding after you've ENDORSEMENT endorsement, when you've completed the endorsement by delivery, okay, you signed it and you delivered it, signed, sealed, delivered, I'm yours, your bearer, okay, that makes them the bearer. Whoever is to receive it, it makes them the bearer. It also makes them the holder in due course. Where a bill or cause of action has been perfected by delivery or an equivalent of proof, the bill was not dishonored. Or in the case of service, where lack of qualified denial of allegations, and we discussed that yesterday. You got to at least deny the allegations. You can't be like, oh, I didn't even get your mail. That's why I didn't address when I received the claim that you were suing me. What that got to do with it? You received the claim, didn't you? Why you didn't answer the claim? File a motion. Show cause hearing. Something to rebut the allegations. Something to rebut the assumptions. We was over here assuming a lot of shit. Qualified denial. You gotta have a qualified denial. That's what a qualified denial is. Of allegations apply, facts stand as truth. So if you do, where lack of qualified denial of allegations apply, facts stand as truth. Okay? That's how that reads. Where lack of qualified denial of allegations apply, facts stand as truth. And you'll hear me when circumstance arise, and I'll explain to you how uh, when a person is making an allegation, and I've said this before, it's only an allegation if you don't have evidence. So therefore, if you are offering inadmissible evidence based on the ground that is hearsay, the opposing party can raise the objection and say, objection, Your Honor. And the grounds that they will be standing on is hearsay. Hearsay has an array of objections. So one of the objections, hearsay inadmissibility, is that they're offering hearsay as an assertion of the truth of the matter. They offering it for truth of matter asserted. They'll say it like that. They offering for truth of matter asserted. Offered for the truth of the matter asserted. It means you're trying to assert hearsay as truth. That's not allowed. That is the objection. You're trying to offer truth as hearsay. You can't do that. It needs to be clear cut. I'm offering this. This is hearsay, but based on these grounds, I have a hostile witness. I'm allowed to do that because the witness is hostile. People don't know that's why you have to remain in honor. If you called as a witness and you think just because your opposing attorney is questioning you that you have a right to be disrespectful to the attorney, you are sadly mistaken. What you have done is allowed the attorney to bend the rules. Now he can ask leading questions. Now he can enter hearsay and offer for the truth of the matter asserted because you're not providing enough information for the court to make a reasonable calculation based on your testimony. So you left room open for them to start hurling out all kind of shit. They can impeach you by any means at that point. And that's all they have to do is say if your lawyer object to their line of questioning is hearsay or there's a different lot of array of objections, but your lawyer object, and then they say, well, I have a hostile. I feel like I'm dealing with a hostile witness, and court practice or the federal rules of procedure, whichever forum you in, you make reference to the rules. And all the rules have it somewhere in there that say the witness can't be hostile. If you're telling the truth, why are you hostile? That means you're acting in dishonor. That's the way the court is allowed to interpret that type of behavior. That they can just overrun you because you're not competent to answer a simple question. I ask you a question, you can say yes or no. It's a yes or no question, Your Honor. Objection. I asked them a yes or no question. They went flying off the handle about something else. I asked them a yes or no question. Objection. I moved to strike everything that they said because that was not an answer to the question. Question was an yes or no question. No, you're not going to just get stuff on the record. If it's a good lawyer, they're going to stop it. And it moved to strike it, what you said. And you just answered a damn question what you was asked. If it's a yes or no question and you don't, and you feel it's designed to impeach you, you are allowed to re-ask the question, rephrase the question yourself. You are allowed to do that. and that would not be considered as hostile. So, because it's considered as clarifying the question, you just restate what they said. So, what you're asking me to answer yes or no to is this. You asking me, was I or was I not? Are you asking me that? Was I or was I not? And then you re-question them. And don't answer the question at all. Just rephrase the question. Let them answer and say yes or no as to if you was correct or not, and is that the answer that they want. But you can be very skilled and crafty and disseminating the impeachment level in the question by redrafting the question. So before I answer the question, I would like to be clear on what the question is. Are you asking me, is my name XYZ? Okay? Is my name XYZ? Yes, that's the question I'm asking. Is your name XYZ? Okay, I just wanted to be clear so that I can answer the question exactly like you asked. And the answer is no. Oh. Oh, so you're saying this is not your name? And she easily say, no, that's not what I'm saying. I'm answering your question. Your question was an answer no question, which didn't allow me the opportunity to explain. So I just answered the question. Now you have impeached his question. Now you have given rise to the merits of the question. Now you trumped his question with a question. This is how you can get a case moved up from a lower court to the higher courts with a question. Question bad motherfuckers, man. I have a question channel. No, we have two question channels. The Ask Candy was first, and then just the generic question channel. Okay. Because I was getting all kinds of questions, and so we just created different platforms to generate questions from all different avenues of questioning, just like we are examining this document. And even at the beginning of the document, we had some questions about what chapter 61, how, where, what the hell, why is this document starting at chapter 61? We got questions about that. We still have a few little questions. We've gotten over the hurdle, but we still got a little pole there on understanding what vested is. We're going to wait and see if we get down and they have some type of understanding of what the word vested means. But we got some questions. Questions help you to learn. Questions help you to identify things that matter and add and give them value so you can equate and understand it. Issues. Issues means the first delivery of a bill. Okay. Issues. Oh man, come on now. We got some issues here. We got some issues we need to deal with. Means the first delivery of a bill or note. Complete in form to the person who takes it as a holder. Oh yeah. I tell you about that holder. That holder something else, baby. Yeah. We like being the holder. But you can't hold too long. You know how they got that what's that country song say, gotta know when to hold 'em, know when to fold 'em, know when to walk away, know when to run. All right. Uh, gotta know when to form 'em and fold 'em and hold 'em. Okay, let's see. All right. Complete in form. Complete in form. And a lot, we talk about forms all the time to a person who takes it as a holder. The first delivery of a bill or note, complete in form to a person who takes it as a holder. So when your credit card company sent you your bill, no, let's talk about the foreclosures. All right, this is a really big deal. Okay, and we definitely want to help people with foreclosure issues. Go get your mortgage. Go get all your papers that you received when you did your closing. Go get all of your papers. I would recommend that you gather all your papers for your foreclosure in one place. And then we're going to do a broadcast just for you. Okay? Gather all of your papers that they gave to you, whatever copies they gave to you, whatever documentations, bills, congratulation notices, anything they sent you along the way. And what I mean by they, I mean any person who was involved, the realtor, the title company, the HOA, Homeowners Association, the realtor from the other side, whatever. I don't give a fuck what it is. If it was a postcard, you need to gather all documents that you have that is related to this matter. You gotta understand what relation is. We always think every time we see the word relationship, we think about like who going with who. Okay? So that is a good way to think about this. You get all the documents that reveal who was going with who and who was in cahoots with who. Because I guarantee you there's some cahoots going on. But you got to be able to get all of them documents. In one place to be able to see that. Okay? We're doing a reading. Let's pretend this is a tarot card reading. Okay? And let's pretend when you get all your documents together and you spread them out on your coffee table or on your kitchen table. You spread them holes out like the tarot card readers. And then you start reading. You'll start seeing everything that they did to you. You'll also see everything you did to yourself. Like, oh, I didn't even read this. This clearly says, oh, man. Go get your papers. Get them. I'm going to tell you like Master say, read it. If you can read them. If you can understand them, read them. As we go through this understanding of the bills of exchange, you'll be able to understand them better and better. But you got to at least start reading them. Because I guarantee you there's something in there in plain sight. If you read it in the manner that we are reading this bill of exchange, oh yes, you will discover. This is the discovery stage of your case. You gotta go investigate some shit. See what you holding. Cause see what it say right here? An issue means the first delivery of a bill or note, complete in form, to a person. You the person, it was complete in form they sent it to, who takes it as a holder. You took it, kept the bill, threw it in the corner. You the holder. You it. That was a hot potato. You were supposed to have signed, sealed, delivered, and sent that motherfucker back. But now you the bearer of the responsibility. Because you the bearer of the note. They going in court talking about they holding the note. How they the holder? How they the holder if you got it? That's what a bearer of false witness is. How are they the holder if you got it? Because you don't know what a note is. You don't know what a promissory note is. You don't understand what a bill is. And I'm starting to even see a different aspect of the word promissory note. Promissory note doesn't always necessarily mean I promise to do something good. The way they have reversed the systems, a promissory note is something bad. Okay, I'll give you an example. When you fill out that bond papers, and then it make you promise to allow them to arrest you. What? Where they doing that at? I ain't signed that shit. You done already arrested me illegally, and then you think I'm finna sign some paperwork to let you arrest me and give you permission to come in and do a repeat? So you want permission to come and do a repeat of the crime? Where they do that? People need to stop signing these bonds. Stop signing them. Got to learn how to sign with a restrictive endorsement. Write in all caps. Your name in all caps. And in lowercase letters, write beneficiary. That'll put some stank in the doo-doo. It'll expose that they are processing these uh, documents in probate court. And it'll expose that they are processing these documents in probate court, making claims that you dead and you're not dead. Because if they are claiming that the beneficiary is dead and you are the beneficiary, then there's some discrepancy in the books. Um, there may be handling you as a deceased entity is what I mean by they have reported that you are dead. Lost at sea. Different types of terminology for the same thing as dead. But you are not dead. You are alive. So what are they referring to? They're not referring to you. They're referring to your name. A name is a dead entity. It's not the person. The person is the person. The name is just what you call or refer to the person as. They doing business as a human being in that name. And they're doing business as a human being. So you can understand what's going on. They're doing business as a human being in that name. And that's what they mean by claiming the name. Some people claim the name. Some people don't want to claim the name. And because I don't think anybody understands anything about this stuff, really. If you haven't correlated the understanding that this stuff get deep, it gets real deep. But it's also, if you take your time and if you choose the right persons to follow and gather and glean from their information banks, then you can gather in some level of understanding, a degree of knowledge for yourself. And that's what an endorsement is. You can endorse your own ideas, okay? You can complete an endorsement, fill out the coupon that come with your bill every month when it come in the mail. For people with mortgages, they're supposed to send you a coupon book. Get that coupon book. Get it out. Learn how to write out a check. Write that motherfucker out like it's a check. Write the amount that it says on that coupon. Write it in Words and figures, just like a check. If your mortgage is $1,500, and so your bills say you are supposed to be processing $1,500, I'll tell you why I said process in a minute. This is the process, okay? If it says it's $1,500, then you would write the words in all capital letters of you can use, I mean, it doesn't matter how you write it. I don't think, I'm not sure about that factor, but I do know that people write checks however they want to, and as long as it is good on the other end, it's irrelevant if you wrote it in capitals. It's even irrelevant if you spelt the words correctly, from what I'm told, because they're gonna go by the numbers anyway. It says if there's an error in the words, then they are to go by the numbers, words and figures. If it's written in words and figures, then they can default to the numbers to determine what the words were supposed to have been, and they can um, what do you call that? Place an allonge on the words and write the correct words. They can place an allonge there and correct that, as long as the numbers is there. And there's a lot of different rules. We'll get into that with the bills of exchange, but there's a lot of different rules that allow people to alter documents. So when people say they forged this and they forged that, you got to understand what it means to forge, to be sure that it's been forged. There may be a different type of offense that they effected when they did whatever they did, okay? And perhaps the charge is not forgery, maybe a fictitious instrument. False and misleading representation, truth in lending, okay? It falls under other perimeters that you can use besides always defaulting to identity theft and forgery. Why would you choose categories that are more difficult to prove? People say fraud is difficult because it's hard to prove intent, but it's not hard to prove intent. When you send them a first notice and then another notice, and say in that notice, if you do not respond to this notice, it is evidence of intent. You created intent right there. If they don't respond, how is intent hard? When they don't rebut your factual statements, affidavit, that proves a level of intent or lack thereof to remedy. That's intent. That's a lack of intent to remedy. That's still another violation. Lack of intent to remedy. You ain't even try to fix the situation. You didn't. You was acting in dishonor. Anytime you act in dishonor, damn near your case is over. Especially if your opponent pointed out. It's hard to climb up from dishonor. I've seen them try to switch lawyers. Well, I don't know why the counsel that was handling this case below did this and did that. The judge know y'all pulled the switcheroo just so y'all can cry mercy on your adequate counsel, ineffective counsel. Y'all uh, and incompetent in due diligence. Just incompetent. You ain't filed no motions. You ain't did shit. Okay, we talking about endorsements now. All right. And that is how an attorney endorses INDO. You endorsed it. All right. You the one making the initial claim. And it turned into an endorsement from them because they supposed to back you up and endorse what you say. INDORSEMENT. Okay? They supposed to be like parrots, saying what you say. Only thing supposed to change is the look, the E and the I. The rest is spelled the same. You endorse it, they endorse it. And that's how you win a case in complete delivery. Prevail in judgment. Notes: where a bill or cause of action has been perfected by delivery or an equivalent of proof, the bill was not dishonored, okay, or in the case of service where lack of qualified denial of allegation apply, facts stand as truth. Okay? So after you done sent your documents in the mail, they don't rebut it. You send another confirmation. Did you get the first notice? And that's not, see, they said there was no sufficient denial. Wasn't a qualified denial, where a lack of a qualified denial. See, lack of, when you don't do things, and this is involving service, when you don't do things, you don't deny the allegations, when you don't have sufficient evidence to support your claim, then the facts that you don't have sufficient evidence stands as truth against you. It don't say that, but you got to calculate that understanding. If the fact stands as truth for you to prevail, then the lack of fact stands as truth against you. Remember, I said, even if it's one, you got to always keep in mind that there's two involved. See, it's one factual statement here, but there are two elements to this one factual statement that are also true. Fact stands as true, that's one, and fact stands as truth against you if unrebutted. With sufficient evidence. You got to have sufficient evidence. And of course, facts are facts. And so they stand as truth because they can't be rebutted, because they're facts. They can only be rebutted with a truth that sets off the evidentiary nature of the fact. The truth overrides the fact. It only stands in the place of, it's supposed to be the bearer, facts are supposed to be the bearer of the truth. But if someone rebuts that the facts represent the truth and can show how show cause of how the facts are not the truth. The truth is, you say the truth is this, you know. The facts is the officer pulled me over and he's allowed to make a report. But also the facts is that was not presented by the prosecution is that police officers lie. And the facts is that police officers make mistakes, and facts is that police officers also do things that are unethical in addition to lying, such as bringing people to jail, taking people to jail, unearthing them from their homes and the peace of their and tranquility of their personal habitats, and so forth. So those are facts as well relevant to the case. They aren't general, they're relevant to the case. And they stand as truth because everybody is familiar with these facts. Now, besides those facts, let me be specific as to how your facts is irrelevant from the truth of my facts. And separate them. Show the irrelevance of their facts by raising your standing in truth. Facts only stand as truth. As truth. That's just like a substitute. That's a substitute teacher. It's not the teacher. That's substitute. You know how I don't know what kind of school system you was in, but when we went to the public school system, and especially if you're in the ghetto community, sometimes at Booker T. Washington, I know one class I never even seen the real teacher. The substitute was the teacher. We didn't even know the actual teacher because we never seen her. And I imagine if she'd have came, because we had different substitutes, I imagine if she'd have came, we'd have thought she was just one of the substitutes. Because she was just standing, because everybody was standing in for her. Okay? Like facts. Facts is standing in for doing the best he can. Okay? But when you come in as a pro se, you're supposed to come in with some truth. Declaration of truth. That override all facts. Stand as truth. Truth stands as truth. Ain't no wavering from that. A fact can be a disannulled as relevant, but the truth cannot. Because the truth expresses intent as well as facts. That's just like when I use the example about police misconduct. When they expressing their facts, okay, didn't you do this, didn't you do that? Okay, yeah, those are facts. But the fact is that's not a crime. And that's the truth. That overrides their standing of just having a fact, a random ass fact. I brought it in. made it relevant to the case, to the grounds of the case that they were standing on, and uprooted their standing in random general facts by pointing out relevant facts that not only are facts but can stand as truth as well. So the truth stands for truth. All right. Now we're gonna get into understanding of what issues is. We started, but a lot of times we have to go back and forth, because that's what dual accounting is. We ain't gonna keep telling you that. Well, we might. Issue means the first delivery of a bill or note. First delivery of a bill or note. Complete in form to a person who takes it as a holder. So you the holder, baby. You holding the note. You got your mortgage loan and you holding it. And you holding the check. And need you to know the note, promissory note, them all checks. Checks. Watch me turn my bill, into a check. That's Mansa song, copyrighted by Mansa. But that song is very relevant to this broadcast at this time because of the fact that once you get an understanding of these words, person includes the body of persons, whether incorporated or not. Okay? And then you can effectuate postal operative means a person, business, entity that provides the service of conveying post all packets. Post all packets. What are post all packets? Post all packets. Okay? That seems to be like any form of postage. Okay? And they're conveying. It's funny how they use the word conveying. Isn't that the same word they use in transferring uh, interest in home mortgage property transactions? When you're buying a home, conveying, you have to convey the deed uh, from one place to another by post or postal operator, any of the incidental services of receiving, collecting, sorting, and delivering postal packets. Valuable consideration. Valuable consideration is what we discussed earlier. And we'll get into that in depth as we go through the bills of exchange. But for now, what we'll uh, do is we'll accept our understanding of the word value, of what we have a common understanding of what value is. Okay, nothing has changed there. But in the bill of exchange, when we're talking about value, we want to relate back to what we discussed the other day about you place the value when we was discussing the federal notes. You place the value when we're talking about your creative works. If you're an artist, you place the value. I was talking about the collectability of federal notes because why?
you create. People say Federal Reserve notes are worthless. That is untrue. That is their intellectual property, and they have some designs that are worth more than the amount that's on the note. That's where you get your collector's notes from, and they are not common, okay? And they have increased or consideration of value beyond the note, beyond the face value of the note. Okay? Moving right along. Written includes handwritten as well as ink printed, and writing includes print and vice versa. Okay? If you know how to write, then you understand that when you are not writing in cursive, you're printing. That's the understanding you got in, a general understanding we got in school. Okay? But they're trying to help you to understand that when they say printed, they mean handwritten or ink printed. Okay? And that is bolded to help you to understand why ink printing is important. You notice the bolded areas, okay? When it's bolded, uh, that's like giving notice, okay? It's a notification area. Pay attention to this right here. See how the words ink printed are bolded? The words written is bolded. Written as well as it's not bolded. And writing includes print, it's not bolded. And vice versa. This is to distinguish between the commonality of the words. Okay? These words are uncommon. Pay attention to this. You've noticed that's what that means when you darken the letters, when you bold them. Printed is equal consideration as handwriting for the purpose of contracting. Whether you wrote, we talked about that in previous broadcasts. Whether you wrote it out in a crayon or you wrote it with a pen, it doesn't matter. A contract is a contract, and it's enforceable. It's an enforceable bill of exchange. It's a transacting. It's a document of a transaction and initiating negotiation to do business. That's showing that you was intending to do business. Shows intent to do business. Part 2. We still at chapter 62, but they didn't put chapter 62 part 2. They just put part 2, bills of exchange, form and interpretation. Bills of exchange define a bill of exchange is an unconditional order. Bills of exchange is an unconditional order in writing, addressed by one person to another. So either that bill of exchange is unconditional order. That's negotiable. If it's unconditional, that means you haven't put any stipulations on it. Oh yeah, some people permission with stipulations. When you get a bond, they put stipulations on you. Say you can't do this, can't do that. That's a motherfucking stipulation. If you're on your job and they say you can't have your phone, you at school that you can't have your phone in your class, that's a stipulation. All right, them conditions. You can stay here or you can continue to work on this job if you on you be doing all your personal shit on our company time. Them the conditions. All right, and so that is not an unconditional order. That's a conditional order. All right, that's a condition of the contract. That's not a conditional order at all. If it's a bill of exchange, it's an unconditional order. If it's a bill of exchange, it's an unconditional order. That means these rules go into effect whether you want them to or not. Mm. They're not based upon no conditions of whether you knew you could, whether you knew you could sign the paper, send it back or not. It's not based upon your knowledge of or lack of knowledge of whether you could do that or not. Send a presentment. Send back in your coupon from your fore, uh, foreclosure package. I mean, your not your foreclosure package, your mortgage package. They sent you some documents and you didn't do nothing with them. Them was your bills of exchange. They was unconditional orders to pay. And you're supposed to pay. And since the conditions was not uh, set in stone, then they have a right to negotiate the conditions and determine you the one that default in the agreement and foreclose on your home. So you got to understand what you did wrong in the process so you can correct it. Go get your foreclosure papers. Go get all your mortgage papers. Go get every single thing that have anything to do with or got the name of the companies that have something to do with. Because I notice also when you dealing with these type of companies, you didn't pay no attention, but you start receiving other documentation from a whole different company. You don't even know where that came from. It was they attached to your mortgage. You have some interest there, and they have to send you documentation. They sending it like it's an advertisement, but it's not an advertisement. Just like I told y'all that the bills of exchange was an advertisement yesterday or whenever the other broadcast was. And I referred to the bills of exchange as an advertisement. Because the bills of exchange is advertising. They advertising that, okay, if you act like this, uh, it, do it according to these parameters, then you're covered under the act. You're covered under this act. That's why they have some protections, the people who are acting in this manner. Okay? This this bill of exchange somewhat gives them the authority to act in that manner. Okay? It gives you the authority to act. But you got to find out where your part in the play is to act. Because you've been missing off stage for a minute. We've been missing off stage for a minute. Okay, order in writing addressed by one person to another. It's an order in writing addressed by one person to another. By one person. to another. See, that's where the consumer credit counselors, they specialize in using this portion of the rules. The rule says that an unconditional order in writing is addressed by one person to another. And a lot of those advertisements that they send you for credit and credit cards and loans and so forth have several different persons on there. And it is even unclear who doing business with who. And it looks like a conglomerate going on. But it's supposed to be one person to another, signed by the person giving it. One person to another, signed by the person giving it. So if you have a lot of names and shenanigans on your presentment, I crosses out one name. One name might not. I cross out the name that don't got shit to do with me. I didn't contract with you. Why is your name on here? For example, Capital One will have Walmart name on there. I'll redact that. Need to redact that. That's two names. So that counts as your name out. That's two names, one, two, three names. I redact their name off of the document and put my name at the top. This is from one person, me, to you. Okay? Whoever my service provider is, Walmart, not the service provider in this particular agreement, their name should not be on this agreement. So consumer credit counselors will tell you to attack that from the perspective that they should not be advertising on your instrument. It's confusing and it's not clear and concise as to what the offer is. It's not clear and concise of what the conditions are. What's the purpose of this communication? Is it an attempt to collect a debt? Well, they're not supposed to be collecting a debt, so that's a crime. They get them on that. And not a crime, but, yeah, not a crime, but an offense. An offense. Okay. So that type of transaction is by one person to another. By one person to another, signed by the person giving it. Okay? Sound like a check to you? Sound like a check to me. I write you out a check. I'm the one giving it. I signed it. Okay? And I require the person to whom it is addressed to pay on demand or at a fixed or determinable future. Time or sum certain in money to order to or to the order of. To, okay, a sum certain in money to or to the order of a specified person or to bear. Okay? So, the other person is the service provider's name, the financial service provider's name. And if your name is on there, them the two people. You don't supposed to have no other people involved. That gets a bit confusing. All right. It said one person to another. And one of those people is the signer. Signed by the person giving it. You the one filling it out, you sign it. You one of the people's giving to the other one person. You have the pay to the order of uh, Capital One. Pay to the order of Bank of America. Pay to the order of whatever your mortgage lender company name is. One person to another. When you write out a check, you don't just start putting a whole bunch of people's name on the check. Paid to the order of Felicia, John, Patrick. You don't just go putting a whole bunch of beneficiary names on a check. Even if you have different beneficiaries, you got to write them all out a check on each one individual. That's why when you name the beneficiaries, you got to name them individually as a beneficiary. They have to have their own separate beneficiary file that say if they're getting a percentage of some amount, what those conditions are, what they beneficiary package consists of. What, are they just getting my old bicycle out the backyard, or what are they getting? That's why each individual beneficiary has to have their own note that identifies them as a beneficiary, and it also declares on there the will of the testator. Some wills have pay on death clauses, okay? Some annuities and so forth that have beneficiaries, they have pay on death clauses already incorporated in that type of financial instrument. So when you invest in those type of products, it already has pay on death. That's automatic. That don't go through probate. It's automatic. That is probate. That's why it's already in probate. The entity was created in probate. That's why it doesn't have to go through probate. It don't have to be reran through probate because it's already rooted in there. The title is rooted in probate. You don't get a full understanding of what roots. These roots. That's how they know all the promises in the book ain't yours. It's already some evidence in the roots. If you're a child of the king, you're going to show you a child of the king. Best believe. We're going to end the broadcast right now because we have embarked upon quite a bit. We need to let that marinate a little bit. And if need be, go back and do a little study on those words if you didn't get it from our explanation. We have the video content for those who in secret chambers. We have they have access to the link. This is a private production, so it will not be released publicly. So if you uh, were fortunate to catch the live, you were blessed to be a part of dissemination of information that's as exclusive is not available to the general public. Blessings.